Settlement of international disputes. An international dispute is defined as a disagreement on a point of law or fact, a conflict of legal views or interests between the states. What really constitutes a dispute? A wrong done to a national of one state taken up by the government of the aggrieved national state constitutes a dispute. The dispute must lead to action by an aggrieved state. The dispute must relate to a well-defined subject matter. Let's discuss the methods of settlement of dispute. The methods of settlement of dispute are of two kinds: pacific means of settlement of dispute and coercive means of settlement of dispute. The pacific means of settlement of dispute include arbitration, judicial settlement, negotiation, good offices, mediation, conciliation, inquiry, and through international organizations. Whereas, coercive means of settlement of dispute include retortion, reprisal, embargo, pacific blockade, and intervention. The methods of peaceful settlement of disputes further fall into three categories: adjudicative methods, diplomatic methods, and institutional methods. Adjudicative methods include arbitration and judicial settlement. Diplomatic methods include negotiation, good offices, mediation, conciliation, and inquiry. Institutional methods include through United Nations and through regional organizations. Legal reference of the Pacific means of settlement of disputes is the Hague Conventions of 1899 and 1907. The General Act for Pacific Settlement of Disputes under the League of Nations, 1928. And the UN Charter, Chapter 6, Paragraph 1, Article 33. Now we will discuss adjudicative methods of dispute settlement. It includes settlement of disputes by tribunals, either judicial or arbitral. Arbitration includes the methods through which a dispute is referred to certain persons, called the arbitrators. The decision of arbitrators is called an award. Legal reference is Article 15 of the Hague Convention. Arbitration is a consensual procedure. The award is binding upon the parties. Nature of the tribunal established is according to the wishes of the parties involved. Development of arbitration as a means for settlement of disputes. History of development of arbitration as a means for settlement of disputes dates back to the Jay Treaty of 1794 between England and America. In the Alabama Claims Arbitration, 1872, U.S. claimed compensation from Britain upon violation of laws of neutrality. It was held in the favor of America. In the Hague Convention of 1899, international law relating to arbitration was codified and led to the creation of the Permanent Court of Arbitration. And the Hague Convention of 1907. Cases adjudicated in this case are: Muscat Dow's case, 1905. North Atlantic Coast Fisheries case, 1910. Savarkar case, 1911. Kutch arbitration of 1968 between India and Pakistan. Let's discuss judicial methods of dispute settlement. Judicial settlement of cases are done at the International Court of Justice. Examples include Australia and New Zealand against France requesting ICJ to grant injunction to restrain France from nuclear tests which adversely affected Australia and New Zealand. Distinction between arbitration and judicial settlement. ICJ is a permanent court governed by its statute. Where arbitration court is not a court but a temporary tribunal. ICJ is situated at The Hague with a permanent registry, where arbitration courts, being temporary, have no permanent seat. ICJ proceedings are public and published. Where arbitration court judgments may or may not be published. Disputes are settled at the ICJ under the international law, and the court applies sources of international law as enumerated in Article 38. Where arbitration courts waive application of law to resolve disputes. Decisions of ICJ contribute to the development of international law. Where decisions of arbitration courts are a mixture of law and politics. They confuse law with diplomatic solutions. Now we will discuss diplomatic methods of dispute settlement. Diplomatic methods include attempts to settle disputes either by the parties themselves or with the help of other entities. First is through negotiation. Negotiation is recognized by a majority of treaties as the first step in settlement of international disputes. It's a voluntary, bilateral, and self-help means. Third party is not necessary in it. It is a very helpful method for clarification and elucidation of opposing contentions. Second method is through good offices. When two states are unable to resolve their dispute, a third state may offer its good offices. These offices may be offered by a state, an international organization, or some individuals. The third party does not take an active part, it only provides a conducive environment. Examples include: UN Security Council offered its good offices in disputes between Indonesia and the Netherlands in 1947. Secondly, France offered good offices to America and North Vietnam to end the Vietnam War. The third method is through mediation. In case of mediation, the third party not only offers its services, but also actively participates. For example, Tashkent Agreement in the end of 1965 and beginning of 1966. Russia succeeded in bringing an agreement between India and Pakistan. The fourth method is conciliation. It is a method through which other states or impartial persons try resolving dispute pacifically by reinforcing matter to a commission or committee. The proposals of commission are not binding on the parties. Hague Conventions 1899 and 1907 made provisions for the Conciliation Commission. For example, 1965 Convention of Settlement of International Disputes between States and the Nationals of Other States. The fifth method is inquiry. Main objective of inquiry: to make investigation of the relevant matters, to establish facts to help resolving the dispute. For example, often an inquiry commission is appointed in relation to the settlement of border disputes. Now we will discuss institutional methods of dispute settlement. These involve the resorting to either the UN or regional organizations for settlement of disputes. First method is through United Nations. Under Article 2 of the UN Charter, it is advised not to resort to force. UN General Assembly may make recommendations. UN Security Council may also make recommendations. Article 33 to 38 of the Chapter 6 of the UN Charter Pacific means be employed. ICJ and the Secretary-General may offer help. Second method is through regional organizations. Article 52 of the UN Charter suggests pacific settlement through regional arrangement or agencies. If settlement of disputes fail through pacific means, coercive means of settlement of dispute are resorted to. First means is retortion. Retortion means retaliation. When a state misbehaves with another, international law confers a right upon the affected state to resort to retortion. For example, in retortion, diplomatic relations will be ended, privileges of diplomats be withdrawn, and economic facilities may face a halt. Second is reprisals. When one state acts illegally or unjustifiably, an aggrieved state becomes eligible to reprisal. When is reprisal justifiable? The UN Charter forbids unilateral use of force and violence by way of reprisal. It is only justified when the opposing state has committed an international crime or violated any rule of international law. For example, Israel's action in bombarding certain areas of Lebanon from where Arab freedom fighters operated attacks back to Israel under reprisal. Third means is embargo. If a state violates international law or commits some international crime, the affected state becomes entitled to create obstruction in the transport of its ships within the territory of the affected state. Fourth means is Pacific blockade. Ingress and egress of ports of states is blocked. It is less violent than war. For example, the Cuban quarantine resulted in the blockade of Cuba by America in 1962 because America contended that Russia was going to supply some nuclear weapons to be stationed at Cuba. Fifth means is intervention. War is the ultimate sanction of international law when all other amicable and forcible means fail. Right to wage war is now restricted by the UN Charter and Kellogg-Briand Pact, 1928.